Hello and welcome to this edition of the Legal Eagle podcast. This month's episode is entitled Children and Young People in the Criminal Justice System. And joining me, as always, is Colin Beaumont. Good morning. Hello, Colin.
Hello, Clive.
How are you?
I'm very well, thank you. Very well. Should I say a word or two about my experience? I normally do, very briefly.
Go on then.
Qualified in 1982, spent 12 years as a legal advisor, re-qualified in 1996, I think it was, as a solicitor, spent 20 years as a defence lawyer. No points on my licence.
Well, you started with your experience, Colin. I feel like I should start with my appearance. I'm looking very slovenly and relaxed today, as you've already commented on. I'm in the middle of moving house, so apologies. No shirt, no tie. Chaos reigns, and I think I'll leave it there. Otherwise, that'll be the end of the podcast. My experience, called to the bar in 2003, didn't get pupillage first time round, so ended up working for a firm of solicitors for a year, where I bumped into you, Colin. And it was an important year because it was around 2003, 2004, and we had a little bit of law, didn't we? Quite some important changes, Colin. The Criminal Justice Act 2003, and we had the Sexual Offences Act 2003. And you did some training, I rather enjoyed it, and we've stayed in touch ever since, and here we are. Is the short potted version. But if I was a prisoner, Colin, they'd say I was half in, half out. And although there was a funny cartoon in the paper today, Colin, judge said in the event, he says, I don't know how long you'll serve or when you'll be released. Of course, referring to prisoners being released early inadvertently from prison, rather than a previous episode of this podcast in which we discussed the early release provisions. I think perhaps we should record an addendum to that, Colin, saying you never know when you might be released early just by accident. So
absolutely. I know 40% has gone down, 50% has gone down to 40%, but release after a day, God, it just seemed terribly generous.
We shouldn't joke because, of course, serious convicted criminals are being released onto the streets. But I read in the paper this morning that the governor of Wandsworth, where the two most recent prisoners have been released from, wasn't at the prison at the time because he was in Chelmsford carrying out a review into how someone had been released early by accident at that prison instead. I mean, you just couldn't write it, could you, Colin?
Could you? No, you couldn't. Well, we shouldn't. We couldn't write it, Clive.
No. We can.
Meanwhile,
anyway, we're not talking about prison today, are we, Colin? We're going to be talking about Young Offenders Institutes, which is a correction the Court of Appeal frequently have to make in their sentencing remarks, isn't it, Colin? When judges, Crown Court judges usually, I'm not criticising them, it's a difficult job, but sentence 19 or 20-year-olds to prison, and the Court of Appeal say, well, he couldn't do that or she couldn't do that, so we'll correct the sentence to the extent we will remark that it is detention in a Young Offenders Institute. We are going to talk about children and young people in the criminal justice system, and following our theme really from last month's podcast, Colin, we talked about bail and a dozen things last time. We're going to talk about a dozen things in relation to children and young people in the criminal justice system, aren't we, Colin?
We are indeed. Shall we kick off with number one? Where ought the trial to take place?
Go on then. Let's just say a bit about the Youth Court, Colin. I used to enjoy going to the Youth Court. It was challenging. It was challenging. The clients were challenging, communicating with them, and whether they turn up, the parents, whether they turn up, or a guardian or a brother or sister. And quite often they came from troubled backgrounds, which added a dimension. And a lot of our clients, when defending, came from troubled backgrounds, but I think particularly in the Youth Court. And then, of course, you had the law, because it was difficult, I found sometimes, Colin, to get into a rhythm in the Youth Court. And I think that's probably even more so today. And I used to go to places like Camberwell Green Youth Court, which I'm not joking, used to sit every day of the week, Colin, because it was so busy in South London. Now, of course, youth courts might sit once or twice a week, or maybe once a week. And as a practitioner, trying to get into the rhythm, just as you think you're on top of something, you'll go and do something else for a few days, and then you go back and you feel like you're not quite in the rhythm. I don't know. Would you agree with that synopsis, Colin?
I really totally would agree with it, because I think a lot of practitioners, they're not comfortable in the Youth Court. And the reason they're not comfortable is because the practices, the procedures, the orders, it's all terribly unfamiliar, isn't it? It's like a criminal lawyer going to the county court to deal with an injunction.
It is almost.
He or she is going to be outside of his or her comfort zone.
And I say that, hopefully, by way of some comfort to people tuning in, because the Youth Court is a tricky place. And we always strive for perfection and to strive to get things right. But when it comes to children and young people, I think we always take that responsibility that little bit more seriously, and quite rightly so. So that's the aim of today's podcast, isn't it, Colin? Hopefully, to make you feel a little bit more comfortable the next time you go to the youth court. So we are going to kick off, as you rightly remarked, Colin, by starting off with where ought the trial to take place? Should we be in the youth court, Colin, or should we be in the Crown Court?
Well, I think firstly to say, of course, is that youth court's jurisdiction is very wide, isn't it? It can deal with those indictable only matters that can't be heard in the adult magistrates court. Rape, grievous bodily harm, intent, robbery, blackmail, that sort of stuff. We had a very interesting case, didn't we? It was BH and Norwich Youth Court, in which a person appeared for the youth court charged with, I believe, 3 rapes. They were quite serious. The prosecution and the defence were both saying, well, it's not really suitable to have these tried in the youth court. District judge took the opposite view, said, no, I've heard your representations. I think the youth court is the correct place for this particular trial. Defence not incorrect. They took the district judge to the High Court by way of judicial review, and the High Court with the district judge, and said, no, wherever possible, the trials involving youths should take place in the youth court, with the possibility of a committal for sentence thereafter under Section 16 of the Sentencing Act 2020, if a committal for sentence is warranted, which will probably be a once-in-a-blue moon event. So that was a clear signal from the High Court, wasn't it, to the effect that even though your sentencing powers may not be sufficient, that is no bar to you having your trial in the local youth court, much to the chagrin of the defence, of course, who might prefer their chances in front of a jury. And, of course, we've got the Judicial Review and Courts Act of 2022, in which Crown Court judges were entitled to say, well, why has this been sent to me for trial? I think this is a matter that can perfectly adequately be the subject of a trial in the youth court. I'm sending it back for trial. So in the unlikely event of a matter being sent for trial, it's by no means guaranteed that it isn't going to be sent back.
That reflects a bit of a sea change, doesn't it, Colin, in the way that we deal with these cases? Because for some time, that was obviously the youth court and its power to commit for sentence taken away from it for some time, didn't it? So the culture and the case law around it was very different, in the sense that we did have to work backwards, in the sense of, right, what sentence are they likely to get? And as a result of that, that would dictate where the trial took place. Now, of course, what sentence the defendant may or may not receive does not dictate, or should not dictate, largely speaking, where the trial will take place. And as you said, indeed echoing what the High Court has said, is the most appropriate place for trials for youths is in the local youth court. The most appropriate place for sentence may be elsewhere. You have to uncouple those two concepts, don't you? And for so long, we've always considered them together. And I think you need to uncouple with where ought the trial to take place, with where ought sentencing to take place, if and should they be convicted.
And I would say the more so with the delays we currently have at the Crown Court. I know they try to expedite the trial, clearly, if it involves the youth, but I think the chances are you're still going to get your trial that much quicker in the youth court than you are at the Crown Court.
Quite, even doing their best in the Crown Court, that their best may not quite be good enough or appropriate for you, as you quite rightly say. So, Colin, let's talk a little bit for a moment where ought the trial to take place. What sort of cases are definitely going to the Crown Court? Let's start with those, shall we?
So cases that are definitely going to the Crown Court, because, of course, the youth court can't entertain jurisdiction. I'm speaking about a homicide, for example, manslaughter, murder, that sort of stuff. Imagine a 16 or 17-year-old in possession of a firearm. Well, of course, there's a consideration there of a minimum sentence of 3 years, which, of course, the youth court can't give. So that's going to be sent. I think minding a weapon for another person also carries the consideration of a minimum sentence above the powers available in the youth court. So there are certain cases which, well, you just can't entertain jurisdiction, and so the matter must be sent. But it seems to me the High Court would say, if you can entertain jurisdiction, you think very seriously before declining.
Colin, you've used the word homicide. Help me with this. What if my client was charged with causing death by dangerous driving? Is that a homicide?
Well, that's an interesting case, interesting example, because once upon a time, the learned editors of Stone's Justice's Manual took the view that it probably was a homicide and you probably couldn't accept jurisdiction. But then we had an interesting document published by the Judicial College. Google it if you can. The Judicial College, Youth Defendants in the Crown Court. Worth a read. It's got a very good table in it, setting out the views of the Judicial College. And there are 6 offences, would you believe? 6 offences, apropos driving, which might involve a death. And the view of the Judicial College is that in relation to those 6 offences, driving, they are all suitable in terms of jurisdiction can be accepted. They are not to be defined as homicide. Interesting.
Yeah, it is. And I specifically asked you that question for that reason. And as you say, that document from the Judicial College is incredibly helpful. And as an advocate, whether you be prosecuting or defending, the best advocates are always the ones who put themselves in the judge's shoes and say, well, how am I going to help? And so, when you turn up, it may be that you're in front of a lay bench. One would hope that the district judge might be cognizant of that document, but it might be they're not. And it may be you are in front of a lay bench. And if you can say to them, look, there's this guidance from the Judicial College, they'll say, thank you very much. That's really helpful. Okay, so it's a really helpful document, as you say, to have a read of and also to bring to the attention of your tribunal, because I'm hoping that that's the advice you've given your client before you've gone in. You're going to say to them, look, there's this document and it says that although this is what we call homicide, where somebody's been killed, actually there's guidance that says the trial should take place here. And if your 15, 16, 17-year-old goes into court and they say, well, we're sending this to the Crown Court, you've got some explaining to do when you walk out. So you've got to be consistent as well, haven't you, in what you're telling your client and indeed what you're advocating in front of the court. So it's a very helpful document. And do have a read and bring it to the court's attention.
I'm sure a district judge would be most impressed if you were to refer him or her to that particular document, because it's by no means certain that the district judge is going to be aware of that document. It's a funny word, homicide. It's an American word, isn't it? Every time the word homicides go through my mind, I think of book him, Dano, murder one, Hawaii Five-0. Gosh, that dates me.
We did have a Homicide Act of 1967, didn't we, Colin? It is a word, but as you say, it's been a word very much used in American English, hasn't it? And covers a broad spectrum of things. And to your point there, Colin, that document is entitled Youth Defendants in the Crown Court. So quite frankly, why should a district judge have read it? Because they're not sitting in the Crown Court. So as you say, don't be surprised if they've not read it or they're not familiar with it. Hopefully they are. But there you are. You can be of real assistance to your tribunal in those circumstances. Good. Anything else, Colin, you want to say about where the trial ought to take place?
I think we need to crack on. Point 2, where ought the sentencing to take place? Well, I think it's fair to say that 99% of the time, the sentence is going to take place in the youth court. It's going to be a rare event that the magistrates or the district judge take the view that it warrants something more than a 2-year detention and training order, which, as we know, is the sentence available in the youth court. It might happen, but it's going to be rare. If it does happen, of course, there'll be a committal under Section 16 of the Sentencing Act 2020. It can only happen as regards serious offences. In other words, those offences punishable in the case of an adult with custody of 40 years or more, or those sexual offences which are tucked away in Section 249 of the Sentencing Act 2020, which, although they don't carry anything like 14 years, are still deemed to be serious offences for the purposes of a possible committal for sentence under Section 16. There's also the possibility of a committal for sentence under Section 17 of the Sentencing Act 2020 in relation to the youth be considered dangerous. Can't see it myself, Clive. I don't think Section 17 will ever be used.
It's going to be rare, isn't it? I always remember the words of the Court of Appeal in the case of Lang, was it, where they said that young people should have the greatest capacity for change. So you should be very cautious as a sentencing tribunal before coming to the conclusion that a young person is dangerous. So if you can trot that out during the hearing at some point, you'll go a long way towards not having your client committed for sentence under Section 17, as you say, Colin.
It nearly happened to me once in Brent, would you believe, until I pointed out that as far as youths are concerned, of course, you can't be sentenced under the dangerous offender regime unless today's offence merits a sentence of at least 4 years. That's the law. And it just happened to be a situation whereby it wouldn't hurt anything like 4 years. And so the district judge was persuaded to keep it. But you have to be on your toes sometimes. I get the view sometimes, and I suppose I shouldn't say this, but I get the view sometimes that district judges, they just want to test you, don't they? Eh? I've never seen him before. Does he know anything?
We'll throw him a curveball, see how he deals with that. Throw him a googly.
I was duty once in a strange court that I hadn't been to very often, and the district judge fired question after question after question at me all day. And then at the end of the day, he said, "You've had a very good session, Mr. Beaumont, haven't you? You've answered all of my questions."
Can I say one thing, Colin, just on point 2, where ought sentencing to take place? I'm sure you've read it. There's a very interesting case from 2023 called ZA, Crown against ZA in the Court of Appeal. And it gives guidance as to how sentencing of youths should take place in the Crown Court. And what I mean by that is in terms of the architecture of the courtroom. Talks about, for example, the judge being sat on the same level as them. Talks about the fact if there are adult defendants, the fact that you should give consideration to sentencing the youth on their own earlier and sooner, that you should also ensure that listing is dealt with appropriately. There is sufficient time for sentencing to take place for the judge, for him or to her to explain themselves in simple terms to the child or young person whom they're sentencing. So it goes through and gives a checklist, the case of ZA 2023. We'll put it in the show notes. We haven't mentioned the show notes so far, but we will put it in the show notes with some links with the details, the citations of cases. But yeah, very important case of ZA. If you are going to go to the Crown Court, you might be counsel, you might be a solicitor advocate, or equally, when you're instructing counsel, you might want to bring this case to the court's attention. Make sure everyone's not robed, that you've got the appropriate time, the judge is sat in the right place, all those sorts of things. So a case, if you've not read it and you are going to go to the Crown Court for sentencing in the youth, you should read it and bring it to everyone's attention. Point 3. Colin, tell us about persistent offenders. How persistent is persistent?
Well, you've got to be aware. It's another one of those, isn't it, whereby a lawyer might be thrown because he or she doesn't go to the youth court very often. And people are talking about the concept of the persistent offender, a concept, of course, not relevant if you're dealing with adults, people who are 18 plus. The concept, in a nutshell, is if you're 14 or below, namely 14, 13 or 12, you cannot be made the subject of detention by way of a detention in training, either in the youth court or in the Crown Court, unless you are deemed to be persistent. Well, what do we mean by persistent? Well, we've got some guidance given to us by the Sentencing Council. They published that document, didn't they? Overarching principles, the sentencing of children and young people, well worth a read. I think that came out about June 2017, in which they said, of course, 14 or below, the offender must be persistent. And then they said, well, how are we going to define persistence? Well, it may be that he or she has had previous findings of guilt against them in the youth court. It may be that they've been in trouble with the police in the past and they've received some disposals of a non-charge nature. So you can factor in what's happened in previous police station visits in determining whether or not someone is persistent. I must say, from my own recollection, Maidenhead Youth Court were very generous in their definition of persistent. They wouldn't define a client as persistent unless it was his or her whole finding of guilt before the court. Well, generous, I thought that was generous.
Very good.
There you are. So added protection, really, isn't it? To keep people 14, 13 or 12 out of custody by way of a detention and training order.
And I think you've made the point before, Colin. We've been teaching other courses that this is a situation where you've got someone who is at a one-person crime wave, haven't you? And you just need an option of locking them up. Effectively, it's the only way to curtail what they're up to. But it is really a measure of last resort, is what the law is saying, isn't it? You have to be, as you say, persistent. And as you say, Maidenhead Youth Court used to give the benefit of the doubt, and quite rightly so.
Well, particularly relevant if your client is a first-time offender pleading guilty, because then they're looking into a referral order, aren't they? Limited options if they don't give a referral order, namely an absolute discharge, a conditional discharge, hospital order, or custody. Well, they can't give custody if they're 14 or below and not persistent.
This podcast is recorded on behalf of Legal Eagle Training. You can find us at legal-eagle-training.com.
Legal Eagle Training has nearly 100 one-hour recordings already on the website, and most of which come complete with notes. We've been doing this now since June 2020 on topics as diverse as
the Magistrates Court, including the Youth Court,
life at the police station,
road traffic,
advocacy, Magistrates Court advocacy, Crown Court advocacy,
criminal law updates, including case law and the latest legislation,
and the subject we both know most dear to your hearts, the billing of criminal legal aid.
The website is constantly being updated with new courses on the latest topics. We add 2 further presentations on the website per month. Each presentation lasts an hour and comes with a full set of notes. Do visit the website, as there's going to be something there that appeals to you as someone involved in criminal law.
Right, back to the episode.
Good. You've touched on it just a moment ago, Colin, but point 4, overarching principles, the sentencing of children and young people. This is another reason, I think, why going to the youth court at times and the other sentencing exercises can be complicated, because they engage a number of different guidelines, don't they, Colin? And so you really have to have your wits about you. You really have to be, as you say, on your toes, and you have to be familiar with all of these sorts of things. But the overarching principles, the sentencing of children and young people, the way we approach sentencing of young people as a general rule is we start off by looking at the adult guidelines, don't we? If you were 18 or over, what would this be worth? And because of your youth, we are going to make a reduction to the starting point. And that very broadly is the way that we approach sentencing of youths and children, isn't it, Colin?
That's right. I mean, if you're 17, 16, 15, thereabouts, the guidelines say, do they not take the adult quantum and then give a sentence roughly between a half and 2/3 of that which would have been appropriate for the adult? If the offender is below 15, gosh, you might want to give less than half of that which would have been appropriate for an adult.
Yeah. And you do that. I think the Court of Appeal have said this, haven't they, Colin? You do that you when arriving at the starting point. And the reason being is that sometimes what happens is that I think sentencing courts have given credit and then made the reduction, haven't they? And actually, when you do the maths, the numbers end up being wrong. So it's really important, the stage in the sentencing process at which you apply that as well, which the Court of Appeal have had a little to say about. And I haven't seen any issues about that recently. So I think the message seems to be out there now.
That's
that
right.
You take that step very early on in the sentencing process.
You do your percentage reduction, you arrive at your sentence, and then you deduct as a final matter, any credit forthcoming.
Just a little bit about that, Colin, because we may or may not get there. But of course, the law in relation to detention and training orders has changed, hasn't it? And for some time, indeed, I think most of my practice, we've always had these prescribed lengths, haven't we? So I think it was 6, 8, 12, 18, 24 were the prescribed periods for a detention and training order. And now, of course, that's been amended, hasn't it, by the Police Crime Sentencing and Courts Act of 2022, saying that the court can pass any detention and training order of length from 4 months to 24 months. And what that allows the court to do is, in my mind anyway, is more accurately reflect credit for guilty pleas. Because I found previously, for a youth, that it was a bit like a game of snakes and ladders. You might have a youth court, a bench of magistrates considering credit for a guilty plea, and they come to a starting point of an 18-month detention and training order. And the defendant, the youth, has pleaded guilty on the day of trial. Now, of course, the guideline on credit for guilty plea says, should you plead guilty on the day of trial, you're entitled to 10%. But the problem was, for the district judge or the lay bench, their hands were tied because they could only go from 18 to 12. Now, of course, 10% of that is 2 months effectively, isn't it? And they should be given a 16-month sentence. But as a youth, you might get a big chunk off, a big whack off, simply because of these prescribed periods that the magistrates or the district judges were bound to sentence you to for a detention and training order.
That's right. Your 18 going out as well, wouldn't it?
Yeah, automatically. So say you slide down at a huge wedge, which you wouldn't have got had you been an adult. So I always found that a little bit, when defending, of course, it was very helpful. But I always found it a little bit unjust, looking at it objectively as an aspect of sentencing. So I think that is a welcome change that we've seen from Parliament, whereby they're saying to the courts, look, you can more accurately reflect this now. And you can pass a 15-month detention and trading order or a 7.5-month one, however long you want to do it. And I think there's good sense in that. So that's a welcome change. Point 5, views in the Crown Court. We touched upon this, haven't we, Colin? The views of the Judicial College. Anything else you want to add on that?
Not really. I don't want to dwell on it. It's safe to say, if you can Google it and get hold of it, views in the Crown Court, it's well worth the read for a lot of interesting stuff. And just because it's got the word Crown Court, it doesn't necessarily mean it's not relevant for your local youth court. It most certainly is.
Yeah, quite. Well, I'll try and find the link, Colin, and put it in the show notes to save people Googling it. But yeah, there we are. Good. Point 6. I know you like talking about money, Colin. Enhanced fees for youth court work, statutory instrument 2024, number 1163.
This is an amazing statutory instrument, bringing into force, of course, the new youth court fees, December 2024. I mean, they were considerably enhanced, weren't they? They are now so much more attractive than the fees available in the adult court. Gosh, guilty plea, lower standard fee in the adult court, £250, £300? Guilty plea, lower standard fee in the youth court, £800 and more. Yeah. Higher standard fee in the youth court, getting off like £1,200. These are incredible fees for guilty plea. These only relevant, of course, if you're dealing with the more serious end of youth court work. We're talking indictable-only offences. We're talking offences either way. If the offence is a summary, there's been no change at all to your youth court fees, and those fees mirror the fees in the adult court. But really huge increases in relation to youth court work for guilty pleas and trials, where you're dealing with something that's indictable only or either way. I would just hope that there is sufficient work in the youth court, as it were, whereby you can get these more attractive fees. I'm told that in some youth courts, they're just very light on work.
Well, I think there's several things on that, if I may, Colin. Firstly, of course, going back to where we started, if Parliament and the courts are going to say that we should be retaining more serious cases in the youth court, then that requires more experienced advocates, whether they be solicitors or barristers or silex or anywhere else. And there has been a challenge, to put it mildly, in attracting the better advocates to go to the youth court to do that kind of work. And of course, the only way you're going to incentivize them to do that is financially. And I have to say that, after the first 2 or 3 years in practice for me, and I enjoyed going to the youth court. I learned a lot and used to co-defend a lot in the youth court. It was good fun to that extent. I learned a lot. But I went to the youth court twice after I was about 3 years court, and both of them were on certificates for counsel. One of them was a £1 million arson. In fact, I think I did 3 arson cases, and they were all certificates for counsel. And so that's the other way you're going to attract people to do it. But I think that the Bar Council and the Law Society, credit to them, they've lobbied hard on this to say, look, we're keeping more serious cases there. The work there is more complex. It's difficult. The witnesses are young. The defendants are young. And the areas of law are complex and difficult. And you need to be remunerating this properly. And happily, as you say, Colin, that seems to have happened. And I hope it means that advocates out there say, don't look down their nose at going to do youth court work, that they actually see this as important and serious work and consider doing it. So there we are. I enjoyed it. Point 7, we're halfway there, Colin. Referral orders for first-time offenders and referral orders for non-first-time offenders. Tell us about first-time offenders, Colin. You've mentioned it in passing already.
I have, yes. First-time offender pleading guilty, never been in court before. First-time offender pleading guilty to might be quite a serious offence. It might be quite a serious offence. And much to the surprise of the advocate who doesn't appear in the youth court very often, the court today allows you to consider a referral order. Gosh, a referral to the youth offending service, whereby he or she signs a contract, in inverted commas, and they do that which the youth offending service want them to do for no fewer than 3 months and no more than 12 months. It's a bit of a cracking result. I remember once the boss coming back to the office saying, "He gave a referral order." He said, "I wasn't quite sure what a referral order was," he said, "but it sounded a cracking result. Bearing in mind the nature of the guilty plea, the offence, my client had just pleaded guilty too." I said, "Yeah, that's what they tend to do. That's what they tend to do in the youth court." "Wow," he said, "I wasn't expecting that." He said, "I was all geared up for an adjournment, PSRs, custody a possibility." Now let's just consider the law for a name, because the law says, doesn't it, that the consideration of whether or not a referral order should be given is a mandatory consideration if it's a first-time offender pleading guilty. And the options, if they don't want to give a referral order, are fairly unattractive. And they've been deliberately made unattractive so as to focus the minds of the court in going for a referral order. What are the options? Absolute discharge, not attractive. Conditional discharge, not attractive. Hospital order, there aren't many of those floating with that. Custody, well, they're loath to give custody, aren't they, to a first-time offender pleading guilty? And of course, unless that person is persistent, if they're 14 or below, they don't even have custody as an option. And so it will sometimes happen that it will come as a very pleasant surprise to the defence advocate that client is dealt with by way of a referral order. Had they been 18 or over, gosh, consequences would have been a good deal more serious for them in the Adult Court or the Crown Court. Can I just deal for a name with the possibility of giving a referral order on your second conviction, or your third conviction, or your fourth conviction? Because the legislation now says, of course, yes, you don't have to be a first-time offender pleading guilty. You might be a second-time offender pleading guilty, or third-time offender pleading guilty. But of course, if it's your second guilty plea, or your third, or your fourth, then a referral order is discretionary. And if they don't want to give you a referral order, then of course they've got all their options available to them. Option perhaps of a fine, option perhaps a community order, the YRO, the Youth Rehabilitation Order. Those options not being available for a first-time offender pleading guilty. Remember, the options if they don't give a referral order: first-time offender pleading guilty, absolute discharge, conditional discharge, hospital order, custody. Also, finally, if it's a guilty plea to a non-custodial offence, then all options are open, even for a first-time offender. And more often than not, it's going to be a fine, I would have thought, if it's a non-custodial offence, guilty plea, first-time offender.
It shouldn't be a surprise, should it, to an advocate, Colin? If they're going to court, they should really know that, and they should be able to give that reassurance to a child or a young person that, look, you're not going inside today, and this is 99 times out of 100, this is what's going to happen. But as you say, the way that Parliament has framed it is very much, they want to give young people a chance. And they say, it's only in the most extreme and serious cases that you should really be considering custody for the first time. Aside from that, we should be trying to give them some help to make sure they don't come back down this path again. And secondly, to your point there, Colin, as well, in terms of, second, third, fourth time offending, it took no glee in this, but I had a couple of clients at Camberwell Green Youth Court, who came up for robbery after robbery after robbery. And one of them was 17. I'd represented him 2 or 3 times before, and he was up, I think, for his third or fourth robbery. And he had a good report. I mean, he got, I think, an intensive supervision and surveillance program, and tagged and all the rest of it. So it wasn't a light sentence, but he wasn't going to custody. And I had a chat with him, and I said, look, you need to be careful. And he said, why is that? I said, because you're nearly 18. I said, and if you keep doing this, I said, you will find yourself in the Crown Court. I said, and if you go to the Crown Court for this, age 18, I said, you'll go to prison. I said, and not just for a while. I said, you'll go to prison for 3 or 4 years. He said, oh, right, okay. Now, sadly, Colin, about 9 months later, I saw him in the cells at Kingston Crown Court, for robbery. He pleaded guilty at the prelim. I mean, the evidence was overwhelming. His previous convictions were compelling. He pleaded guilty, and we walked out of there that day with 3 years, and his feet didn't touch the ground. And sadly, I'd warned him.
Yeah, no.
But yeah, it's a real shock to youths when they just tip over to being 18. And but for his previous convictions, things may have been different, but probably not. But yeah, you can warn them all you like, but yeah, sadly, you don't want them to get to that stage where all of a sudden they are being dealt with relatively gently, and all of a sudden they get a real shock when they're locked up for what effectively it'd be 18 months for him.
Clive, you've fallen into the trap of saying prison. You didn't mean prison, did you? We'll give you another chance
You're
for you
right.
18-year-old. Hey,
I made the point at the start.
Smug or what?
Pride comes before a fall, Colin. So.
Just so we're clear,
Very good.
the Sentencing Act 2020 is very clear. It says, look, if you're 18, 19 or 20 at the point of conviction, your sentence is detention in the unattended institution. If you're 21 or over at the point of conviction, your sentence shall be deemed a term of imprisonment. If you're 70 or below you at the point of conviction, your custodial sentence shall be a detention and training order.
Point 8 then, Colin. Age at first appearance. Age at first appearance. This is important, isn't it?
It is very important, and it's sometimes overlooked, of course, because the client was, 17? He had the commission age of offence. 17, that's at the point of charge, or these the exposition and everything, bringing them to court. They're 17. Would you believe when they arrive at court today, 6th of November, they're 18. They're in the wrong court. It is your age at first appearance which determines in court. You must be 17 or below to be in the youth court. You must, on your first appearance. And of course, if you didn't issue her and a warrant, not that the bear was issued for your arrest, and you're 18 at the time the warrant is executed, that warrant lies to the adult court. Why? Oh, because you have to be 17 or below on the occasion of your first appearance. It doesn't say the first listing of the case. It says first appearance. The client might actually rather like, because he might want to elect.
Yes.
He might.
Well, quite. I mean, that's advice you might want to give at the police station, isn't it? Look, if you want this case to be dealt with in the youth court, I recommend that you turn up. However, if you fancy a jury trial and you didn't turn up at the first appearance and you kept your head down for a week, then next time you turn up, you'll be in the adult magistrate's court and you can have a Crown Court trial. So what happens, Colin, if I have a birthday while I'm in the youth court? I had a birthday yesterday, as you know, Colin. But what happens if you have a birthday while you're in the youth court? If you turn up and you're 17 and, by the time you get to trial, you've turned 18 and I've been convicted and now I'm 18, what are they going to do with me?
It really is a matter for them. But in my experience, if you become 18 at the point of conviction, they're likely to keep you and to sentence you in the youth court. They could, if they wanted to, remit you to the adult court for sentence. But I must confess, I never, ever, ever saw it happen.
Why would they do that?
Well, let's all deal with the sections that we made. In relation to these sections, and the Court of Appeal say, we're not really as okay with these sections as we should be. We're back to our old friend, the Sentencing Act 2020. Clive, we'll actually do a link to the Sentencing Act 2020 in the show notes. That would be nice.
Can do that.
Yeah. Committals for sentence, sections 14 through to 24, 14 through to 24. Remittals from one court to another, sections 25 through to 29. 25 through to 29. And if you look at those sections, 25, 26, 27, 28, 29, one of them, I think it's about section 27, so that if a youth attains the age of 18, he or she may be remitted to the adult court for sentence. But it never happens in my experience. I had a phone call once. I won't tell you who it's from, but I had a phone call once. The person that Abdi was on, now 18, Colin. They're 18, Colin. They were 17 when they were convicted, but they're now 18. Can I still give them a youth rehabilitation order, a YRO? And the answer is yes. The legislation says that so long as you are 17 or below at the point of conviction, you can still be given a while. Oh, he said, that's great. That's great. I'll go now.
You can tell me when we stop recording who that was.
Yeah, not as bad as one I got the other day, whereby the phone rang and I picked it up and it said, Colin, we're in court and you're on speakerphone. Everyone can hear you. I said, I better be careful. Better be careful what I say then.
Good job they haven't started recording the magistrate's court yet, Colin.
I'll link him to a funny story. Once upon a time, my client was 17 in the right court, first appearance, got adjourned for one reason or another. I know not why. But when he came back on the adjourned date, Clive, he was 18. Yeah? And we hadn't yet pleaded him. And so I said to the magistrate, look, he's now 18. You must treat him as an 18-year-old. We have to deal with allocation and sending, which rather threw the youth court because they said, well, we don't normally deal with allocation and sending in the youth court. I said, no, you don't, with respect, because you don't normally have people before you who are 18 prior to plea, but you do today. So we have to deal with it. The legal advisor wasn't wholly convinced, but, we're broughting round. And my client elected. The legal advisor wanted to transfer the proceedings to the adult court. And I said, if we're going to do that, can you show me some authority? I'm not sure there is any authority. There certainly wasn't at the time to transfer him to the adult court. I said, why don't we just get on with it? And he can elect to them. I know they're sitting as the youth bench, but they're adult magistrates sitting in the youth court. We can become an adult court if you want. I don't think we need to become an adult court, but if it'd make your life easier, I said, let's just sit as an adult court for 5 minutes. Nothing can stop me from electing.
There we are. Question 10. I know you like this topic, Colin. Children and young people jointly charged with adults.
Yeah, you get them, don't you, in the adult court? You have to have them in the adult court, I suppose, if they're jointly charged with adults or they're charged with offences arising out of the same circumstances as the adult. Might be an indictable only offence. Might be an idle way offence. I think the interesting question is always, isn't it, if the adult elects, or if for one reason or another the adult is sent to the Crown Court, must the youth automatically follow? Well, my view is no, not necessarily. The court should always consider whether or not to sever in the interest of justice and perhaps take a plea and deal with the matter in the adult court using their very limited sense of the options in the adult magistrate court. See section 25 of the Sentencing Act 2020, or more likely remit to the youth court. We had that document, didn't we? Published by the Sentencing Council, March 2016, allocation and sending. We've also had that document published by the Justices Clerk Society, haven't we? Giving guidance to the justices as to whether or not they should sever, use, and remit to the youth court for sentence, even though that may be 2 trials, one at the Crown Court for the adult, one in the youth court for the youth.
Very good. And I have to say, Colin, that the law used to really approach it from a different perspective in terms of what the interests of justice were, didn't it? In terms of keeping them together. The interests of justice were best served by witnesses not having to give evidence twice, the risk of inconsistent verdicts. I remember making those submissions on more than one occasion, whereas now the interests of justice are obviously very wide, but it really feels like the defendant, and particularly the youth, the young person, that their interests are put at the heart of this rather than the wider interests of perhaps the prosecution and the public at large.
I think it follows the general principle of we keep children and young people away from the Crown Court wherever possible. The younger they are, the more we'd want to keep them away from the Crown Court. And if the witnesses in the case of police officers, well, what's to stop police officers giving evidence twice in 2 trials? Nothing at all. Might be different, of course, if you're dealing with lay witnesses, particularly if you're dealing with vulnerable or child witnesses, in which case you wouldn't want them to work necessarily having to get involved in 2 trials. So, it really is judicial decision based upon the factors for and the factors against.
I don't think the youth court's got any power to order a noting brief, has it, Colin? It's the kind of thing, whereas if you were going to be representing defendants in the Crown Court, you'd quite like to know what the witnesses said in the Youth Court. So there we are. You might, I suppose, write to the court and try and get the legal advisor's notes. But there we are. Point 11. Bail or remand into custody, Colin. And if remanded into custody, what type? Again, this is where there are layers of complexity within the youth court system and youth justice system that don't exist in the Crown Court and in the adult magistrates court generally, are they, Colin?
Absolutely. I mean, you've got to have your wits about you, haven't you? If you're going to the Crown Court knowing that your client was charged last night and kept in custody and is appearing in the youth court today, you've got to have your wits about you. And it may be the prosecutor is seeking your client's remand. Well, the first question really is, what sort of remand do you want, Malcolm? Hey, do you want to remand it into the care of the local authority? Because if you do, well, I think my client can live with that, as they'll probably send him back at home. In my experience, prosecutors are very wary of seeking a straightforward remand in the care of the local authority because they have those pesky custody time limits to contend with. Yeah. Albeit Luke, he's back at home with Mum. Yeah, a woman who has absolutely no control over him whatsoever. Hey, what was the point of that, said Malcolm. So it might be an application for remand into the care of the local authority. Of course, if it is, the Bail Act applies. The prosecution must show one of the exceptions to bail in the schedule at the back of the Bail Act, but they tended not to apply in my experience. Much better perhaps to agree a package of conditions. Yeah, more stringent conditions. Let's put him on conditional bail. Of course, wholly different considerations apply if they're seeking a remand into youth detention accommodation. Yeah, in which case, you better get the books out because you're looking on sections 98 and 99 of LASPO, the Legal Age Sentencing and Punishment of Offenders Act 2012. And to cut a long story short, there's two categories of people who might find themselves on the receiving end of an application for a remand into youth detention accommodation. They are those offenders who are charged with violent or sexual offences, or offences which in the case of an adult child 14 years or more, and it's necessary, say the prosecution, for them to be remanded into youth detention accommodation to protect the public from serious harm or death from them. Category 2 are more complicated, aren't they? Category 2 offenders are your one-person crime wave. Yeah, they're not committing offences of the most serious nature, but they're committing offences whilst already on bail. They're committing offences whilst already remanded into the care of the local authority. And the CPS take the view, we have to bring this mini crime wave to a halt. And the only reason we can do it is by an application for a remand into youth detention accommodation. But a number of boxes have to be ticked. So make sure you're familiar with section 99 of LASPO and the boxes that need to be ticked.
Yes. Good. Finally then, Colin, but by no means least, and we touched upon this right at the outset, but number 12, orders that may be made against parents or guardians. And sadly, in mine and I'm sure many others experience that one of the predominant reasons why youth find themselves before the courts is because one or both of their parents are no longer present.
Difficult, really. Difficult.
Sometimes it would be big brother or big sister who come along as their guardian as well.
Yes, true.
Yeah.
It may be that there's a mandatory order being made. Of course, the Sentencing Matter, our old friend, the Sentencing Act 2020. The Sentencing Act 2020 says, look, if you're imposing a mandatory order like a fine on someone who's age 16 or 17, you first of all look to the offender. Do you have the wherewithal to pay this fine? And if you do, we direct that you pay it. If, however, age 16 or 17, you don't have to wear the law, in default, we're going to make your parent or guardian responsible for payment. And they will be summoned in the event of non-payment. It's different, of course, if the offender is 15 or below, when the order is always made against parent or guardian. In relation to other powers available in the youth court, well, of course, the youth court could order the parent or guardian to be bound over to exercise proper care and take proper control of their child.
An interesting case we've touched upon sentencing or already going through or dealt with in a bit of detail sentencing, but there's a case I always remember, the case of B against Leeds Crown Court, Colin. Do you remember it, where the defendant was sentenced to 8 months imprisonment for a couple of aggravated vehicle takings? And the reality was, of course, had he been an adult, the maximum he could have received was 6 months. There were some other offences as well. Interestingly, so he appealed the decision from the Youth Court to the Crown Court, and the Crown Court wanted to give him a 3-month detention and training order. When they came back in to announce that, counsel pointed out, very gently, I'm sure, said, "I'm sorry, you can't impose a 3-month detention training order." So they were, "Oh, fine, appeal dismissed then." So they wanted to reduce his sentence quite substantially. Anyway, the case ended up for the divisional court, but it's a good read. It's a good read because it illustrates your point, Colin, that youth should never be dealt with more seriously than adults. And, youth is always a mitigating factor and never an aggravating factor within the criminal justice system. Also, it's a really good example of some excellent advocacy, in terms of persuading your court, telling them what you want and why they should give it to you, writing judgment for the court. He says, look, this was what's wrong with it. This is why they shouldn't have done it. And this is why you should allow the appeal. And they said, yeah, we agree for all the reasons given by counsel. You're doing the divisional court, as it was in that case, their job for them. It's a really nice judgment to have a read of. Great. Anything else you want to add, Colin?
Only to add that I think the last hour has been illustrative of the fact that, the Youth Court is a very different place. It's been taught, hasn't there, over the years, but people having to acquire special training if they want to venture into the Youth Court. I personally always been of the view that that's probably a good idea.
No, when I renew my certificate to practice each year, although I haven't practiced for some years now, there's a box I have to tick saying, do I do youth court work? And if I have, then have I undertaken specific courses? So it's certainly there for barristers and the bar. It's on there. It's a specific box I have to tick. If I'm going to go to the youth court, I must have undertaken specific training.
Because I made the point very early on, didn't I? That if you don't go to the youth court very often, if you only enter the youth court very rarely, you're never going to keep this sort of information in your head, are you? You need to be a regular there in order to keep on top of all the beliefs.
Psychologists call it reinforcement theory, Colin. Doing the same thing over and over again. And that's what you need to do, really, to get in the groove of practicing in the youth courts. One last point from me, Colin. We've had a youth justice charter recently. There's a short video explaining it online, and I shall add that to the show notes as well. I think that's something worth being mindful of. But there we are, Colin. So if you either are going to the youth court or considering going to youth court, I'd encourage you to do it. It's an interesting and challenging place to practice. It stretches you as an advocate, as a lawyer, and indeed as a person. And I think it's a really interesting and fascinating place to practice. And sometimes it was those cases, the arsons, Colin, the 13-year-old boy setting fire to something at the end of the school holidays. I had a couple of those cases where they were acquitted, and you think, do you know what? I'm never going to see you again, but you know that you've made a real difference to their life because a conviction then really could have changed the path of their lives. So it's rewarding work as well. That's the note I'd finish on, Colin.
Excellent. Say goodbye, Guy.
Goodbye, Clive.
Well, thank you for tuning in to this particular edition of the Legal Eagle podcast. We do hope that you've enjoyed it. You can find further episodes on our website, legal-eagle-training.com. On behalf of myself and Clive, thank you. Say goodbye, Clive.
Goodbye, Clive.